Hey, boys and girls, Todd Vandermide back again for another edition of Freedom Steel. Former NRA contract lobbyist, Illinois gun law guru. Tonight we have a bit of what we'll call Freedom Friday. So we've had some developments throughout the day, and yes, we're still waiting through the 1,400 plus pages that the state filed yesterday in the gun ban cases in southern Illinois. But starting off, a judge in Macon County has found in the circuit court that the state's semi-auto ban under 1.9 and 1.10, the magazine ban, are unconstitutional with regard to equal protection claims. So, they said, pursuant to Illinois Supreme Court Rule 18 and in accordance with the court's findings above, the court further finds that A, Section 24 1.9 and 24 1.10 of the Criminal Code of 2012 violate the Equal Protection Clause in Article 1, Section 2 of the Illinois Constitution, and the Special Legislation Clause in Article 6, Section 13 of the Illinois Constitution. My Roman numerals get me screwed up at times. B, Sections 24 1.9 and 24 1.10, the Criminal Code are facially unconstitutional under these provisions of the Illinois Constitution. C, Sections 24 1.9 and 24 1.10, the Criminal Code cannot be reasonably construed in a manner that would preserve their validity. D, the finding of unconstitutionality is necessary to the court's decision and judgment, and this decision and judgment cannot be rested upon an alternative grounds. So with that, this judge has declared that the gun ban and the magazine ban that were passed in January are unconstitutional under what look to be equal protection claims. There are also a claim about Article 22 of the Illinois Constitution, which is the state right to keep and bear arms clause. So everybody wants to know, what does this mean? There's a hint that since the judge found the law unconstitutional on its face, not in an as-applied challenge, that this could apply statewide. Now, I'm going to tell you what everybody's going to go check with your own attorneys. I understand this. I think that to be the case, but I'm not an attorney. And if gun stores just start selling stuff tomorrow, remember, you still have a state license as well as your federal license that you have to answer to. And I don't want to give people bad, advice on things. That's why I'm not giving you any advice. I'm telling you to check with your attorneys because this judge has declared it unconstitutional, and it's going to take a couple hours here to wring all this stuff out. We're also looking at what implications this may have with any of the other cases. But what's going to happen is the AG's office is going to appeal this up the chain as a direct appeal to the state Supreme Court. The state Supreme Court may or may not issue a stay of the injunction. If they do issue a stay, then it's right back to where we are, when we woke up this morning. Otherwise, they'll clarify whether or not the law is enjoined and if that is, in fact, statewide. We'll see if that creates any controversy or not with the federal cases, but then you will get a briefing schedule, probably in an expedited way, for this case to then be argued in front of the state Supreme Court. People said, well, if they lose, there's no going to federal court after this one because all the claims contained within here are state claims. They are all about process, single subject, due process, equal protection, and Section 22 of the Illinois Constitution. So those are all state claims. There are no federal claims in this one. So we'll see. Along the lines of talking about gun bans, today in Viramontes, the challenge to the Cook County semi-auto ban, the county filed a 56-page motion for judgment. So they have filed a 56-page motion for summary judgment in this case. This case has been largely stagnant for a long time. And not too long ago, the ISRA and their lawyers made a move to have this case stayed pending the outcome of the state cases down in Southern Illinois. So what's going on here? My bet is that Cook County has been typically dragging their heels on this. So Cook County has asked for several extensions. At one point, when their briefs were due in July of last year, they asked and were granted an extension till September because the New York case had been handed down. So when it suits them, they want to drag their feet. They want to take forever. But now, when they see that you could have a judge in Southern Illinois hand down a claim or a decision, an opinion that finds the state ban unconstitutional, which will have a ripple effect to Cook County, Chicago, Highland Park, Aurora, and many other towns like that, they want to try to get in front of it. What they want is their record in front of the court. And they filed like 15 exhibits or something like that. And I've looked at a couple of them. One is a report from a committee hearing the House had last year when they did their dog and pony show on gun violence. Understand, none of this has to do with the New York test. This is all them playing to an appellate court or possibly the Supreme Court in order to try and get another bite at the apple at an interest balancing approach. That's all they're trying to do here. So you have this movement in the Cook County case, and we'll see where that goes in relationship to whether or not it gets ahead of us with the Southern Illinois cases or not. Then you have Morris v. Rowell, the suppressor case, the first suppressor case filed. And with that, they were supposed to go to mediation. The state and the plaintiffs filed a agreed upon motion today that, no, we don't want mediation. I think they are being pushed by the case filed by and supported by the American Suppressor Association, Anderson, because now they're in front of Judge McGlynn. And that case may move a little faster. So you've got that. And then in Texas today, so in Vanderstock, the 80% or the new Freeman receivers rule came down, and a preliminary injunction was issued against ATF on behalf of Defense Distributed. They found that they're likely to prevail on their claims, and therefore there is a preliminary injunction against the ATF for enforcing those new rules on frames and receivers against Defense Distributed and their customers who are not otherwise prohibited. At the same time, the Texas Court of Appeals today came out and they issued a revised opinion in Rihanna. Now, you knew about a month ago they came out with this decision saying 922G8 that civil orders of protection on prohibiting firearms ownership, possession, the like, from people who are under a restraining order for alleged domestic violence. Well, they added to their opinion today and strengthened their opinion. They added a section where it appears that Mr. Riani was not ever represented by counsel, was not in front of a hearing, and this was some sort of just agreed upon order. And then one of the judges on the panel just takes off on this and says if there really is a case for domestic violence, they need to be tried, convicted, pretrial detention, all that stuff. This should not be in a civil matter. So overall, a good day in the courts for Second Amendment types today. And with that, you know, things are just going to we're going to keep peeling away the layers of the onion as we keep working on stuff. And I spent a good chunk of today dealing in conference calls and stuff like that on our Illinois cases. Don't worry, I haven't forgotten about any of that stuff. We're just trying to assess what we believe the gaps in the state's case are, where they messed up. They messed up a bunch in a lot of places, and we're going to get to exploit that and explain it to them. So with all that, Friday evening, hope you guys are having a good night. This is just an update from around the four corners of the country to see what is going on, making sure I'm not forgetting anything in my notes. So as always, please like, subscribe, copy and paste the link to this video to others around there, and I will catch up with you, try to get some more content out this weekend. But as always, thank you very much for your continued patronage, watching our videos, and as always, frag out.